All lies. All the participants must note the following instructions. Each team will get 45 minutes time for the final round. Participants are not allowed to use any electronic devices like mobile phone, laptop, tablets, etc., as it may lead to disqualification. 5 minutes extra are reserved for the rebuttal round. Participants are not allowed to leave the courtroom during the proceedings. Chits to the speaker can only be passed by the researcher of the concerned team. The court is now in session.
The present counsel, appearing on behalf of the appellants, appreciates the gracious presence of the bench, but for the sake of brevity, requests to address the bench collectively as your lordship. Much obliged. The present counsel now asks permission to state the jurisdiction. Much obliged. The petitioners have approached this honorable court of Indira Pradesh under Article 226 of the Constitution of Indiana. Permission to now proceed, your lordship. If your lordship is well versed with the facts of the case, the counsel requests to proceed with their arguments. Yes, your lordship. Your lordship, the case pertains to Ms. Neha Singh, your lordship, and Mr. Rohan Malhotra, who have been in a live-in relationship for 7 years in Metrolaya, Indira Pradesh. Your lordship, in March 2023, Sneha discovered that she was pregnant. On July, during a routine prenatal diagnostic test, it revealed severe fetal abnormalities, including anencephaly and congenital heart defects, which are incompatible with life. On August, Sneha and Rohan decided to terminate the pregnancy and approached Metrolaya General Hospital. A medical board was constituted, which denied this contention. They further approached the High Court, and another medical panel was set up to examine this condition, which also rejected their appeal. Your Lordship, now we are here before your Honorable Court. If you proceed with the argument, much obliged. Your Lordship, the first issue pertains to whether the 20-week restriction under the MTP Act violates a woman's constitutional and legal rights. Your Lordship, it is humbly submitted that the 20-week restriction under the MTP Act of 1971 violates a woman's right to privacy under Article 21 and further infringes upon Article 14, which guarantees equality to all. Your Lordship, it is humbly submitted that the 20-week restriction is not based on medical necessity in this case, but is an arbitrary legislative cutoff. Your Lordship, Article 14 guarantees equality and prohibits arbitrary state action, as reinforced in state of West Bengal v. Anwar Ali Sarkar. The Honorable Supreme Court has ruled that arbitrariness is anti-ethical to equality. The present restriction disproportionately affects women who detect fetal abnormalities late, particularly those in rural areas with inadequate healthcare access. Your Lordship, I have a certain data here with me, and according to this, only 22% of respondents were aware prior to becoming pregnant that the procedure of abortion was even legally available to unmarried women. Your Lordship, here it is.
Just to confirm, what is your team code?
25.
25.
Yes, Your Lordship. The appellants, Your Lordship, Sneha Singh. May I proceed, Your Lordship? Yes. Yes. Your Lordship, it infringes on equality right, particularly for those women who detect fetal abnormalities late. Your Lordship, the MTP Act came out in 1971. It does not properly include the modern medical advancements which have come after its enactment, Your Lordship. May I proceed, Your Lordship? Much obliged. Your Lordship, further, while Section 3 of the MTP Act, Your Lordship, allows abortion beyond 20 weeks, Your Lordship, if a medical board finds substantial risk to a woman's health or fetal abnormalities. Your Lordship, it is stated that under the Section 3 of the MTP Act, it gives certain rights, Your Lordship, and defines how this medical board should proceed and what are its formations. Your Lordship, just 1 second, Your Lordship. Come here. Your Lordship, it is presented. At the very foundation of the rule of law lies one basic principle. Statutory commands are not suggestions, they are mandates. Your Lordship, and in the present case, the statutory architecture of the Medical Termination of Pregnancy Act, particularly Section 3(2)(d), has not just been overlooked, it has been blatantly disregarded. Your Lordship, the law as laid down under Section 3(2)(d) of the MTP Act explicitly mandates that the medical board shall consist of a gynecologist, a pediatrician, a radiologist or sonologist, and such other members as may be notified by the state. Your Lordship, now I draw your attention to Annexure number 2. Your Lordship, here, if you look at the board members which constituted this panel which refuted her claim to an abortion, Your Lordship, it states that the board members are Dr. Kavita Sharma, obstetrician and gynecologist, and Dr. Arjun Desai, fetal medicine specialist, Your Lordship. This is Annexure number 2, Your Lordship. Your Lordship, you may note that no sonologist or radiologist was present, which is explicitly required to be present to form a valid medical board. Your Lordship, the state-appointed medical board includes, as I have already stated, a gynecologist and a fetal medicine specialist. Your Lordship, but not a radiologist. It is a direct violation of the express mandate of the law when the legislature has consciously laid down a precise composition for such a board. It is not, Your Lordship, for the state to rearrange or reinvent it. Your Lordship, imagine the consequences of allowing an incomplete medical board to decide on matters as grave as viability of a fetus and the mental health, Your Lordship, of a mother. The board's findings are rendered legally unsound from the outset because the very authority to form such an opinion arose only through a lot which was not adhered to. Your Lordship, this illegality is not isolated to the state's panel alone. Even the High Court's own much obliged. Your Lordship, even the High Court's own much obliged. Your Lordship, even the High Court's own appointed panel, as per Annexure 3, Your Lordship, included an obstetrician, Your Lordship, Dr. Rajesh Gupta, Dr. Priya Mehta, fetal medicine specialist, Dr. Amitabh Roy, pediatrician surgeon, and Dr. Suresh Menon, a neonatologist, Your Lordship. Again, you will note that this panel too didn't include a sonologist or a radiologist as is required by the law to even form such a panel. Your Lordship, here is the annexure. This is not a clerical error, Your Lordship. This is a repeated statutory omission, Your Lordship, which goes to the very root of the matter. The diagnosis at hand, anencephaly, as noted in Annexure 1, is one that is inherently dependent on accurate radiological imagining and expertise. Your Lordship, how can a panel assess a condition like this without the very specialist equipped to interpret such laws? or even such scans. Your Lordship, a radiologist or sonologist is not an optional presence in such matters. They are the primary interpreters of ultrasound data, Your Lordship, and they form the clinical lens through which fetal abnormalities are identified and evaluated. The presence of a fetal medicine specialist cannot substitute the role and clinical function of a radiologist or a sonologist. Further, the omission does not stop there, Your Lordship. Despite the known and documented diagnosis of the severe depression by the petitioner, as also noted in the prop itself, Your Lordship, neither the states nor the High Court's panel included a psychologist or a psychiatrist, Your Lordship, as was rightly pointed out by the independent medical panel too. This undermines not only the legality of the composition, but also the completeness of the assessment. When, Your Lordship, particularly mental health is a core consideration in the petitioner's case. Further, Your Lordship, we are not arguing against medical opinions, Your Lordship. We are arguing against an opinion given by a body that had no legal authority to issue it in the first place. This is a case where the letter of the law has been breached, Your Lordship, explicitly. And therefore, any report issued by such a panel is vitiated in the eyes of the law. Your Lordship. Yes, Your Lordship. Yes, Your Lordship. It has been directly stated. Your Lordship, a radiologist is a medical doctor, Your Lordship, whose job includes interpreting, Your Lordship. Yes.
On what should be the treatment or the diagnosis. Any
Yes.
not an expert,
Yes. Lordship, Your Lordship, the radiologist and the sonologist, Your Lordship, they will indeed provide the data which the doctors will then consult, Your Lordship. And Your Lordship, sorry. Yes, Your Lordship. Your Lordship, we are just stating that if the person who even provides the data was not even present on the panel, Your Lordship, then what will the doctor consult with? Much obliged, Your Lordship. Your Lordship, further, the Indira Human Rights Commission has also recognized this limit, this 20-week limit, as arbitrary and harmful in their reports. Your Lordship, as stated in the annexure itself. Here it is, Your Lordship. Your Lordship, the Honorable Supreme Court has held that the right to health is an integral part of Article 21. In this case, Sneha Singh's diagnosis from Metrolaya Hospital shows severe health risk for both the fetus and herself. Your Lordship, making any legal restriction forcing her to continue the pregnancy not only unconstitutional but life-threatening. Your Lordship, moreover, as held in XV Principal Secretary Health and Family Welfare Department, the Supreme Court has also recognized reproductive choice as a fundamental right under Article 21. Your Lordship, the 20-week restriction infringes on this right, forcing women to carry non-viable fetuses despite the availability of medical advancements. Your Lordship, the fetus in this case suffers from anencephaly. If I may directly quote the definition as has been provided and cited also by Ames, Your Lordship, it states that anencephaly is a condition that prevents the normal development of the brain and the bones of the skull. The condition results when a structure called the neural tube fails to close during the first few weeks of the embryonic development. Your Lordship, further, because these nervous system abnormalities are so severe, almost all babies with an encephaly die before birth or within a few hours or days after birth. Your Lordship, the fetus also suffers from severe cardiac defects as well, on top of anencephaly. Conditions which are both incompatible with life. Denying an abortion in such a case serves no legitimate state interest and inflicts undue physical and psychological harm, violating Sneha Singh's dignity, a core element of Article 21. Your Lordship, the Honorable Supreme Court has previously even permitted abortions at 24 and 25 weeks in cases of fetal abnormalities and mental trauma. Your Lordship, to deny relief in this case would be an unjustified departure from established legal principles. Your Lordship, in conclusion, it is humbly submitted that the 20-week restriction is an unconstitutional and must be extended if not outright struck down. Your Lordship, this honorable court must uphold the fundamental rights of women, ensuring their reproductive autonomy, dignity, and equality under the law, enabling them the right to make decisions about their own body. If Your Lordship is satisfied with my contentions, I would request to proceed with issue 2. Much obliged. Your Lordship, it is humbly submitted that the existing legal framework does not sufficiently safeguard the rights and welfare of children born from live-in relationships. The absence of clear legal recognition perpetuates social stigma, affecting the psychological well-being and societal acceptance, rights guaranteed under Article 14 and 21 of the Constitution. Your Lordship, the ambiguity in the legal framework discriminates against these children, violating the fundamental right to equality under Article 14. Your Lordship, the state has a duty to protect the interest of vulnerable groups. The state's obligation extends beyond mere non-discrimination, as it must create an environment where all children are treated equally, as held in Vikash Kumar v. Union Public Service Commission. Yet, societal and legal biases continue to subject such children born from live-in relationships to undue scrutiny and stigma. It is humbly presented that the Honorable Court has also highlighted the absence of clear statutory provisions for live-in relationships, which create unnecessary hindrances and necessitate judicial creativity to protect children's rights in such cases. It was stated in Tulsa v. Durghatia, Your Lordship. Further, the current legal framework creates artificial barriers, denying them equal protection and making their access to rights uncertain. Such discrimination is arbitrary and unconstitutional, requiring urgent intervention. Your Lordship, further, it is submitted that dignity is an essential component of Article 21, as I have also stated before, Your Lordship. The Honorable Supreme Court has also held that the right to life extends beyond physical survival to living with dignity, as held in Menka Gandhi v. Union of India. Your Lordship, the Delhi High Court, Your Lordship, has also recognized that failing to provide children born from live-in relationships such rights, which are also guaranteed to children born from traditional marriages, Your Lordship, is a clear violation of their Article 14, as held in ABC versus the state NCT of Delhi. Your Lordship, the Supreme Court has multiple times necessitated judicial creativity to protect such children's rights. It clearly shows the judiciary's recognition of the importance of protecting these children and ensuring their seamless integration into society. Lordship, while certain judicial pronouncements have extended protection to these children, statutory laws remain ambiguous. Your Lordship, Section 16 of the Hindu Marriage Act, 1955, provides legitimacy to children from void or voidable marriages, but does not explicitly mention children born from live-in relationships anywhere. Your Lordship, further, while Section 16(3) of the Hindu Marriage Act provides limited statutory relief to children from live-in relationships among Hindus, no parallel laws such as those exist under personal laws such as those governing Muslims. This results in unequal legal safeguard based on religion, contrary to Article 14's guarantee of equality, Your Lordship. Your Lordship, further, a uniform religion-neutral statutory provision would ensure that all individuals in live-in relationships, regardless of faith, receive equal protection. Your Lordship, thereby guaranteeing their right to equality under Article 14. Your Lordship, further, the denial of... Your Lordship, we are trying to establish that the state does not sufficiently safeguard the rights of children born from live-in relationships. I'm sorry, Your Lordship. Pardon? No, Your Lordship. Your Lordship, we are stating this here before because one, it was specifically mentioned in the issues, Your Lordship, that how does the law necessarily safeguard the rights? Yes, Your Lordship. Much obliged. Your Lordship, the state's obligation, Your Lordship, the denial of statutory rights here, Your Lordship, to children violates international human rights as well. Your Lordship, Indiana has closely adhered to the principles of United Nations Convention on Rights of Children, particularly Article 2, which prohibits discrimination based on a parent's marital status. Your Lordship, yet the legal framework departs from this commitment, contradicting Indiana's obligation to ensure equal treatment for all children. In conclusion, Your Lordship, it is humbly submitted that the current legal framework fails to adequately protect the rights and welfare of children from live-in relationships. The lack of legal clarity results in discrimination, legal uncertainty, and economic vulnerability, clear violations of Article 14 and 21. Your Lordship, in light of these pressing concerns, it is humbly prayed that the Honorable Court recognize the urgency of this issue and direct the state to enact clear statutory provisions, ensuring that no child is disadvantaged due to the nature of their parents' relationship. If Your Lordship is satisfied with my contentions, I would request to proceed with issue 3. Much obliged. Your Lordship, the petitioner respectfully submits that the state's deployment of AI-based surveillance system violates constitutional rights. Your Lordship, this issue pertains to whether the state's deployment of AI-based surveillance systems such as Matri Suraksha and Jivika AI violate constitutional rights and other legal rights of a person. Your Lordship, the indiscriminate collection and processing of legal personal data by AIs such as Jivika and Matri Suraksha AI, Your Lordship, continue an unjustified intrusion into individual autonomy, fail the proportionality test, and lack a proper legislative framework, making them unconstitutional. Your Lordship, it is humbly submitted that the deployment of AI-based surveillance mechanisms by the state directly contravenes the right to privacy as established in K.S. Puttaswamy v. Union of India. Your Lordship, here in an excerpt from this judgment, Your Lordship, K.S. Puttaswamy versus Union of India, it has been clearly held the right to privacy is an element of human dignity. The sanctity of privacy lies in its functional relationship with dignity. Privacy ensures that a human being can lead a life of dignity by securing the inner recesses of human personality from unwanted intrusion. Your Lordship, the court has also held in Miss X v. Hospital Z, reaffirmed that medical confidentiality is a fundamental aspect of privacy. This AI surveillance system, such as Jivika AI, process highly sensitive data, including reproductive health information, without informed consent, leading to unconstitutional breaches of privacy and direct violation of established precedents and laws, Your Lordship. Further, the report by the Indiana Human Rights Commission, Your Lordship, highlights that Jivika AI disproportionately tracks unmarried women and individuals in live-in relationships, Your Lordship, violating their privacy rights. In May X v. Principal Secretary Health and Family Welfare Department, the Supreme Court recognized reproductive autonomy as part of the right to privacy. Your Lordship, the AI's targeted surveillance undermines this autonomy by subjecting certain individuals to high-end scrutiny, reinforcing social biases. Your Lordship, as evident in Annexure 4, the AI-generated report by Proxima AI flagged Ms. Neha Singh's pregnancy due to her unmarried status. Your Lordship, this constitutes a clear violation of her rights to personal life and autonomy. Justice Call in K.S. Puttaswamy's judgment emphasized that privacy encompasses individual autonomy and protection from state and non-state interference. Your Lordship, the state's use of AI-driven surveillance without safeguards contravenes this principle. Your Lordship, it is respectfully submitted that the Jivika AI's biased algorithm violates Article 14 by discriminating against individuals based on their marital status. In X v. Principal Secretary, Health and Family Welfare Department, the Supreme Court held that marital status cannot be an arbitrary ground for discrimination in reproductive rights. Your Lordship, similarly, in Suchita Srivastava and another v. Chandigarh administration, the court ruled that women must not face discrimination when exercising their bodily autonomy, Your Lordship, and reproductive rights. The AI system's selective tracking reinforces stigma, violating the principles of equality and non-discrimination. Your Lordship, the Annexure 4 demonstrates that Jivika AI's design disproportionately focuses on detecting illegal sex determination rather than ensuring maternal health care. Your Lordship, this system bias disadvantages marginalized groups and deepens the digital divide in healthcare access. Your Lordship, documents reveal that predictive care, a private entity, has financial incentives tied to detection rates rather than accuracy, Your Lordship. And this predictive care is the very entity which created the AIs which are being used by the state. Your Lordship, in Novartis AG, the Union of India, the Supreme Court has also held that healthcare access must not be sacrificed for corporate benefits. A principle that Jivika AI's prioritization of surveillance over care appears to violate. Your Lordship, Justice D.Y. Chandrachud in Puttaswamy's judgment, Your Lordship, laid down proportionality test, stating that any infringement of privacy must be sanctioned by law, necessary for a legitimate state interest, proportionate to the needs for interference, and subject to procedural safeguards. Your Lordship, Jivika AI fails this test. There is no law which sanctions this intrusion into privacy. There is no legitimate state interest which can be achieved by violating a woman's personal autonomy and collecting her data without her consent. Proportionate, Your Lordship, it is indeed not proportionate to the need as it directly violates her fundamental rights, which are inalienable, Your Lordship. Your Lordship, in People's Union for Civil Liberties versus Union of India, the Supreme Court emphasized that surveillance must adhere to due legal process, a requirement unmet in this case. Your Lordship, the use of AI in sensitive areas like healthcare without transparency or oversight poses serious risks. Your Lordship, Annexure 6 reveals that investigative reports link Metro General Hospital to commercial surrogacy networks exploiting legal loopholes. Your Lordship, with AI regulation, such malpractices can go unchecked, exacerbating constitutional violations. Your Lordship, further, in Manohar Lal Sharma v. Union of India, the court held that surveillance must, without transparency and accountability, is unconstitutional, Your Lordship. In conclusion, it is submitted, Your Lordship, that the state's deployment of AI-based surveillance system violates fundamental rights under Article 14 and 21. Your Lordship, the absence of proper legal framework, the disproportionate nature of surveillance, and the discriminatory targeting of individuals, Your Lordship, renders these AI systems unconstitutional. The petitioner respectfully urges this honorable court to intervene and prohibit the use of AI-based surveillance that lacks accountability, transparency, and due process, thereby safeguarding the constitutional rights of the individuals. Yes, Your Lordship.
Oh, okay. My one question to you is,
Yes, Your Lordship.
what is your argument that there should be no collection of AI data or it is required to be regulated?
Your Lordship, AI data can indeed serve a legitimate interest, Your Lordship, but it is clearly mentioned in the prop as well that this data is biased. this AI is biased. This only targeted and flagged the case of Miss Neha Singh because she was unmarried. Your Lordship, further, the data was collected without her consent.
Are you, have you got the data to say that it is only her case which got flagged and all rest were of married women? On what basis are you saying that it is a standalone case which has been flagged?
Your
See,
Lordship, this
in the these maternity hospitals, every woman who is going, her data is getting collected by AI. Why? Because of MTP Act, they don't want any against the statute any abortion being done.
Yes,
The
Your Lordship.
second object is that there is a lot of selective sex related terminations which are happening, which is known. And essentially, why ultrasounds also are being monitored is only for this reason that there is no indiscriminate sex determination and to keep a check. Do you not think AI, in fact, is helping you to collect the data and you can, in case of MTP, check that it is not sex related or it is for genuine reasons? Is collection of data per se bad, or it's being not regulated, or indiscriminate access being provided to everybody, which is the problem area?
Your Lordship, what is problematic?
And to add what ma'am has stated,
Yes, Your Lordship.
that these rules which you are challenging and you are terming them to be unconstitutional were not framed keeping Sneha in view. They were framed for the general public well in advance before this came appeared in the scene on the scene.
Pardon, Your Lordship, may I request you to please repeat?
Yes, you say that the rules have targeted Sneha, but the
Yes.
rules were not framed when Sneha's case has come up. They were framed much in advance when Sneha was nowhere in the scene.
Yes, Your Lordship.
So how can you say that Sneha is targeted by these rules and regulations?
Your Lordship. Your
You
Lordship,
can say it is prejudicial to Sneha. You can also say it violates equality, as you said, that the government should protect the equal protection should be applied by the state.
yes, Your Lordship.
But how do you say that the Sneha alone has been targeted?
Your Lordship, this is what we are contending, that this limit is now arbitrary. Your Lordship, if I may be allowed.
Yes, yes.
Much obliged. Your Lordship, this is what we are contending, that the 20-week restriction is arbitrary. Sneha Singh's case may not be the only case. It is just the case which got highlighted, Your Lordship, and brought before Your Lordship. Your Lordship, this is what we are stating, that what is wrong is the collection of data without any consent, Your Lordship. This is what we are contending. Your Lordship, indeed, female feticide is a very valid contention, Your Lordship, for AI's deployment, but it does not justify violating a woman's fundamental rights under Article 14 and 21 just to serve a state interest, Your Lordship. Your Lordship, she should not be sacrificed just so that societal concerns can be more thoroughly addressed in the future. Your Lordship, when pertaining to a woman's body, the decision should indeed lie with the woman herself. Your Lordship, indeed, the husband may have a say, but the one giving birth in the end, Your Lordship, is the woman herself. And it should be her decision which matters most. And further, Your Lordship, we are not stating that there should be no regulations to hold this. Your Lordship, we are just stating that the regulations are now outdated. Through various exceptions which are being granted by the court itself, beyond the 20-week restriction, Your Lordship, it shows an increased trend, Your Lordship, that such cases are now being detected late of fetal abnormalities or even of sexual assault, Your Lordship. Your Lordship, thus, the number of exceptions are becoming a norm. This is what we are contending, Your Lordship, that the restriction be increased. If Your Lordship is now satisfied with my contentions, I would request to invite my co-counsel up to the dais to proceed with further arguments. Much obliged, Your Lordship.
Permission to proceed with my arguments? Much obliged, Your Lordship. Your Lordship, the matter revolves around whether judicial oversight in abortion decision unjustifiably infringes on a woman's right to timely medical care and reproductive autonomy. Your Lordship, I stand before this honorable court today to humbly assert that abortion decision oversight does unjustifiably infringes on a woman's fundamental right to timely medical care and reproductive autonomy. Lordship, the right to make a decision about one's own body is the very essence of personal liberty, a right enshrined under Article 21 of the Constitution. A woman's decision to terminate a pregnancy is a deeply personal decision, often made under distressing and unavoidable circumstances. Your Lordship, the MTP Act entrusts medical profession, not courts, with the responsibility of determining the necessity of abortion. Lordship, Indiana's amendment law makes abortion more accessible and safer. If I may present this to Your Lordship. A WHO report stating which makes medical board more competent to make decision on these matters, which is primarily a medical process and an extremely time-sensitive one at that, Your Lordship. Your Lordship, I would like to bring to the attention of Your Lordship an analysis of abortion cases between 2019 to 2020. Lordship, 84% of the abortions were allowed and 87% of the petition were filed after the 20-week mark. Your Lordship, these figures reflect a dereliction in the legal pronouncement pertaining the burden on judiciary, which further proceeds to make this process more delayed, Your Lordship. Lordship, judicial intervention in abortion matters disproportionately affect vulnerable women, those carrying fetuses with several abnormalities, those facing health risks, and those who are economically weak. Further, the Honorable Court decision in Halo B versus State of Madhya Pradesh, Your Lordship, rightly recognized that compelling a woman to carry an unwanted pregnancy causes irreparable harm, Your Lordship. Likewise, in Lakshmi Mandal versus Deen Dayal Haridhan Hospital, Lordship, laid bare the tragic consequences of forcing women to carry unwanted pregnancies, especially marginalized women, which causes irreparable damage, Your Lordship. In the present case, Sneha Singh, the undue delay, as stated in para 11, last line of the prop, has subjected her to the mental agony and physical risk. Such intervention is not merely an inconvenience. Lordship, it is the very infringement of her fundamental rights. Your Lordship, consider a case of A minor versus State of Madhya Pradesh, where judicial delays forced the petitioner to continue an unwanted pregnancy. In XV Union of India, a 27-year-old woman facing severe depression was denied abortion due to a divided judicial opinion, that is a split verdict, Your Lordship. Your Lordship, the consequences of such decisions are not abstract. They are real, they are severe, and they are irreversible, Your Lordship. Lordship, the right to reproductive autonomy is the center to human dignity. Denying timely access to reproductive health care violates a woman's emotional and physical well-being, subjecting her to undue scrutiny. Lordship, forcing a woman to continue an unwanted pregnancy violates her bodily integrity and exasperates her mental trauma, as abortion is a largely physically challenging situation, Your Lordship, which has severe consequences on both the mental health as well as the physical health, which often leads to delays, which also often gets exacerbated by judicial delays, Your Lordship. As I mentioned, the number of cases, the burden of cases around these cases, as I presented the data of the High Court, it exasperates the burden on the judiciary, and this burden further causes more delays, allowing the medical practitioner to give their decision on this makes the whole process more efficient and effective, which provides women bodily autonomy, Your Lordship. Yes, Your Lordship.
Intervention is what is contributing. But where cases in which the patient is but these are all cases which is all beyond the period which is specified. So who has delayed?
Your Lordship, there are various factors to the delay in this case. Lordship, I would like to bring to the attention of Your Lordship in the case of A minor versus State of Madhya Pradesh, where judicial delay themselves force the petitioner to continue unwanted pregnancy. In these cases, Your Lordship, of course, the delay is severely towards the judicial oversight. Of course, the medical board's approval constitutes in this, Your Lordship, especially in this case where the medical board fails to analyze to assemble a proper board to assess this situation, Your Lordship. If Your Lordship is satisfied, may I conclude this issue? Much obliged. Your Lordship, judicial oversight in abortion cases does not safeguard women's rights, it suppresses them. I urge this honorable court to affirm the right of women to make autonomous decisions regarding their own body, free from undue judicial intervention. The law must protect and the court must uphold women's dignity. The right to abortion is not merely a medical necessity, it is a matter of fundamental human rights. If Your Lordship is satisfied with my contention, I request to proceed with issue 5. Much obliged, Lordship. Your Lordship, the issue revolves around whether the findings and conclusion of AI-based systems such as Jivka AI are legally admissible as evidence in medical and judicial proceedings. Lordship, we stand before this honorable court today to humbly submit that AI-based system, particularly Jivka AI, lack the reliability, legal admissibility required in judicial and medical proceedings. Lordship, relying on such technology threatens fairness, due process, and constitutional rights. Lordship, Jivka AI fails to meet the evidentiary standards under section 39 and 40 of the BSA. Your Lordship, in Anwar PB versus PK Bashir, the Honorable Supreme Court held that digital evidence must be verified, authenticated, and open to scrutiny, a requirement that Jivka AI simply does not fulfill due to its opaque algorithmic system, Your Lordship. Lordship, similarly, in the case of Tommaso Bruno versus State of UP, the Supreme Court emphasized independent scrutiny on electronic evidence, which is impossible with Jivka AI's algorithm, Your Lordship. The council would like to bring to the attention of Your Lordship para 12 of the moot proposition, which clearly states the inherent bias in its training data disproportionately targets marginalized groups, further compromising its liability. This was also held in the conclusion of Annexure 4, if your lordship might direct the intention. The absence of human oversight in AI generated conclusions render them legally unsound. Lordship, AI works on historic data set which perpetrate already existing bias, and therefore it cannot generate new data as it's working on pre-existing data. In a country like Indiana, which where there's pre-existing deep-rooted biases and stigma, it is all the more prevalent that it does not fit in this current case, your lordship, as it will be more problematic, your lordship. How can AI generated evidence be admissible if they are inherently flawed and biased, which has been held in the annexures, your lordship? No regulatory body is currently governing AI. No one to hold accountable for the discrepancy caused by it. Your lordship, it has also has to be clearly stated. If I may bring to the attention of your lordship, para 3 of the mood proposition, which clearly states that the information of Sneha Singh was automatically logged into the data, which violates privacy rights as no consent was taken from Sneha Singh. Your lordship, the information was passed to a private entity which prioritizes detection rate over accuracy, a private entity that is inherently biased, a private entity that is under investigation for surrogacy malpractice, as it has been stated in para 14 of the mood proposition, your lordship. Your lordship, judicial reliance on scientific methods demand rigorous validation. In Selvi versus State of Karnataka and Maharashtra versus Damu, the Honorable Supreme Court ruled that unverified techniques are inadmissible. Jivika AI, plagued by miscalculation, error, and algorithmic bias, lacks the scientific legitimacy to apply for this, your lordship. Moreover, in Justice K.S. Pattaswamy versus Union of India reaffirmed that any state action must meet proportionality standards. Jivika AI, functioning as an opaque black box, denies the individual their right to challenge adverse findings and violating procedure fairness. Lordship, Article 21 guarantees the right to fair trial as granted under the landmark case of Hossainara Khatun versus Home Secretary, State of Bihar. AI generated evidence without transparency, accountability, or cross examination directly undermines this right. Internal reports from Predictive Care Private Limited reveal profit driven incentives prioritizing detection rate over accuracy, making Jivka AI's finding highly susceptible, as it has been stated in para 13, fourth line of the prop, if your lordship might kindly direct the attention. The Honorable Supreme Court in Haryana versus Bajrang Lal rule that administrative action must not be arbitrary. Your lordship, AI generated conclusions immune to scrutiny place undue reliance on unverified technology and violating this principle. Your lordship, AI lacks the ethical reasoning, contextual judgment, and judicial essential for medical and judicial decision. Your lordship, the wrongful classification of Sneha Singh's case of pregnancy as an illegal sex determination case highlights the risk of replacing human expertise with AI. Lordship, the Honorable Court in Vincent Perleka v. Union of India ruled that medical decisions require medical evaluation. Jivka AI's automated conclusions devoid of human discretion are legally unattainable, your lordship. Lordship, Jivka AI's findings are unreliable, unscientific, and constitutionally inadmissible. Its opaque algorithmic bias and lack of human oversight threatens the very fairness and due process, your lordship. Admitting such evidence would undermine judicial integrity and fundamental rights. Your lordship, we therefore urge this honorable court to categorically reject AI-generated findings as legally admissible evidence, your lordship. If your lordship is satisfied with my contention, I request to proceed with the prayer.
Just one question.
Yes, your lordship.
What was the illegality you are talking about in this AI application? What is being collected illegally and being used illegally, which is against the objective of the act?
Yes, Your Lordship. As I mentioned, the automated information, it took the personal data of Sneha Singh, which was automatically registered. Personal data, which is very sensitive given the current situation, Your Lordship.
Was
Wi-
it used or sold or made available to any third party?
Your Lordship, this AI driven, your Lordship, this has been used in, as stated in Annexure 6 and para 14 of the mood proposition, which states a link, a found link between surrogacy malpractices and the hospital, Your Lordship, using this AI to form connections, Your Lordship. If Your Lordship is satisfied, may I proceed with the prayer?
No, so the argument is that there should not be any AI application to collect the data of the women visiting the hospital, or you are saying that this AI has to be subject to stringent regulations? What is your contention?
If I may, Your Lordship, we are simply contending that as of right now, there are two requirements that AI must fulfill. Firstly, the stringent regulation. Secondly, the inherent bias needs to be rectified, Your Lordship, which will take time. We are working with situation of Sneha Singh, whose rights have been violated, and we cannot wait for this for regulation to be properly enforced and for the AI to rectify itself while it continues to violate rights, Your Lordship. So until regulatory framework and rectification, periodic audits, transparency are maintained. Until that happens, AI evidence cannot be administered currently, Your Lordship. It is only after where we can keep up with global best practices. Not right now, as of right now. If Your Lordship is satisfied, I request to proceed with the prayer. Much obliged. Lordship, it is humbly submitted before the Honorable High Court of Andhra Pradesh, Indiana, that in the light of the above argument, cases, and authorities cited, the appellant humbly prays before the Honorable Court, first, to hold that the 20-week restriction under the MTP Act violates women's constitutional and legal rights. Second, to hold that the legal framework does not sufficiently safeguard the right and welfare of children born out of live-in relationship. Third, to hold that the state's deployment of AI-based surveillance systems such as Matsishaka AI and Jivika AI violate constitutional privacy rights and other legal rights of a person. Fourth, to hold that judicial oversight in abortion decision unjustifiably infringes on a woman's right to timely medical care and reproductive autonomy. Post-remo, to hold that the findings and conclusion of AI-based systems such as Jivka AI are not legally reliable nor legally admissible as evidence in medical and judicial proceedings, and pass any other order, direction, or relief that it may deem fit in the interest of justice, fairness, equity, and good conscience. For this act of kindness, the appellant shall duty bound forever pray. Much obliged.
What is your prayer 3?
Lordship, to hold that the state's deployment of AI surveillance systems such as
And what about the courts? Which prayer is that? Prayer
third,
number 2, about the oversight of the courts that you were talking, there should not be. What is that?
Your Lordship, that is issue.
Interventions of the high courts.
Yes, Your Lordship.
Which prayer is that?
Fourth, Your Lordship.
Can you read it again, please?
Yes, Your Lordship. To hold that judicial oversight in abortion decision unjustifiably infringes on a woman's right to timely medical care and reproductive autonomy.
So you were trying to say that all these cases which get covered under MTP should not be entertained by the high courts. What is your prayer?
No, Your Lordship, we were simply contending that majority of these cases should rely to the MTP Act, and they should given proper regulation and legislative to act on these matters, which reduces burden on the judiciary and prevents any undue delays, Your Lordship. May I proceed, Your Lordship?
One input from me. You all are young budding lawyers and we are here to learn. One thing for the benefit of everybody, I would like to just highlight, whenever you are referring to any document, these kind of downloaded website pages which are neither here nor there, these kind of articles should not be submitted. The second aspect is that if you collect some information herein, then give the primary information, not what is the opinion of XYZ who's posting this article. Thirdly, there is an amendment act apparently which has been notified in March. Has it been notified or not? So when you are coming with this kind of article, which says Amendment Act becomes effective from 5th March 2025, which came into force, there is this Amendment Act which is come in 21. So it says the gestational period has been increased from 20 to 24. Where is that? Is it under 21? What we were arguing was only on 20 weeks. So where is this 24 week incorporated? So you should always clarify to which part of the act and which section you are referring, right? And these articles is the most incorrect way of supplementing your arguments. Likewise, this data for data that you are submitting, this article has no legal value. So if you are able to get anything from any article, go back to the source and pick it from there. Either the data from the CRB, national bureaus, or from the recognized sources. These articles are not correct. It is the opinion of the person who is posting it. Whether it is legally sustainable or not is a moot point. This is almost like a AI writing your judgment. God knows whether they are correct or not, right? So this is not pertaining to this moot point, but generally, this is not the right way of relying on any kind of data. So always go to the primary and take out the judgments and refer to the judgments, not to these articles.
If I may, Your Lordship, the
Yeah.
article you are referring to was delivered by WHO, and we are merely giving the data of the sources,
This is not
not
the right way.
the
This is not the right way. What I'm trying to tell you, this is not relating to this problem, but when you go to the court, always get the primary source data. Never, these articles have no meaning and value. They may give you an insight where to look and for what to look, but this is not a document on which any court can rely. That's all I'm trying to tell you, that when you do your researches and go to the court, don't produce these kind of articles from the net.
Yes, Your Lordship, the council humbly apologizes for this overlook. Yes, Your Lordship.
My input is because I'll give my final comments, but this is only for the information of all, that this is not the right way, right?
Yes, Your Lordship.
The council seeks permission to address the bench collectively as my lords. Much obliged, my lords. May I first hand over our compendiums? We are appearing as counsel for the respondents in the present case of Ms. Neha and Mr. Rohan versus Metrolaya General Hospital, Predictive Care Private Limited, and the state of Andhra Pradesh. With the permission of the court, we would like to brief the court with the facts of the case, unless the court is already aware. Facts may be skipped. Thank you. At the outset, the counsel for the respondent would like to mention to this honorable court that the petitioner's written submissions as well as the oral submissions are slightly incomplete because the correct and all concerned parties have not been referred to, and the current proceedings are constantly being put across as appellate proceedings, whereas the current proceedings are a writ petition has been filed under Article 226 of the Constitution. Now, moving on, there are 5 issues before this honorable court today. I will be delving into the first 2 issues, whereas my co-counsel will be dealing with the other 3 issues. The first issue before this court is that the 20-week restriction under the Medical Termination of Pregnancy Act 1971, which is the MTP Act, is not violative of a woman's constitutional and legal rights. With this regard, I will first be addressing how the 20-week restriction under the Act is a reasonable restriction under Article 21 of the Constitution. The right to personal liberty under Article 21 is not an absolute right and is subject to reasonable restrictions. As also mentioned in the Constitution itself, Article 21 reads, "No person shall be deprived of his life or personal liberty except according to procedure established by law." The restriction of 20 weeks, which has been imposed by the MTP Act, is a legislative mandate which aligns with the constitutional requirements of being a just, fair, and reasonable restriction. The state has a legitimate interest in protecting the maternal health of the mother as well as the life of the unborn child. Further, there is a medical and scientific rationale behind the 20-week restriction, which includes increased medical risks for the mother as well as the right to life of the prospective child itself. At this stage, I would like to draw the attention of the Honorable Court to page 9 of the compendium, where the case of Suchita Srivastav versus Chandigarh administration has been cited. Under paragraph 2 of the same judgment, the court states, "However, in the case of pregnant women, there is also a compelling state interest in protecting the life of the prospective child." Moving further, in the instant case, the petitioners discovered the pregnancy in early March of 2023, as has been highlighted in paragraph 2 of the moot proposition. However, the decision to terminate the pregnancy has been taken only on August 15th, 2023. Therefore, the respondents contend that the delay in decision-making was a matter of personal indecision rather than being a constitutional infirmity in the law. At this stage, we would also like to draw the attention of the Honorable Court to page 3 of the written submissions of the petitioner, where the petitioner contends, which has also been contended in the oral arguments, that any legal restriction forcing a woman to endure a life-threatening pregnancy is in direct violation of established precedents. However, the counsel for the petitioner has failed to provide any authority for the same contention. Further, I would draw the attention of the court to para 10, which has also again been contended by the petitioners in their oral arguments as well. The petitioner cites 2 cases and holds that the court has upheld a woman's right to terminate a pregnancy at 24 and 25 weeks respectively, citing mental trauma and fetal abnormalities. We would like to bring to the court's notice that the cases cited by the petitioner in this regard, both in their oral submissions as well in the written submissions, are incorrect. There has been no case which says that the court had allowed the pregnancy to be terminated in the 24th week because of mental trauma. The case actually, in this case, the court had allowed the pregnancy to be terminated because it was a case of sexual abuse. Secondly, there was the case which has been cited by the petitioner in the same line. The second case which is cited also says the petitioner contends that abortion was allowed at 25 weeks due to fatal anomalies. However, in this case, my lords, abortion was not even allowed. Moving on, we would once again highlight that the legislative intent behind the provision in the MTP Act is very clear. It strikes a very delicate balance between reproductive autonomy of the woman as well as the rights of the fetus itself. And therefore, at the same time, it also prevents the misuse of late-term abortions and the possibility of sex determination. Our second contention in the same regard is that the 20-week restriction is a reasonable classification under Article 14 of the Constitution. Now, under Article 14 of the Constitution, the Constitution guarantees equality before the law, but permits reasonable classification based on, firstly, intelligible differentia. In this case, the intelligible differentia criteria has been clearly met by the MTP Act, because at 20 weeks, the fetus reaches a developmental stage where it is considered, firstly, it's considered viable. Secondly, there is a need to protect the mother's health as well. And thirdly, terminating a pregnancy beyond this point raises ethical and legal concerns about the rights of the fetus. Therefore, the restriction has been placed keeping in mind all these 3 points, and therefore the restriction meets the criteria of intelligible differentia. Secondly, there exists a rational nexus between this classification and the objective of the MTP Act. The objective of the Act is to ensure that the abortions are safe and legal, and as well as to prevent the misuse of abortion laws. The restriction aligns with Indiana's obligations to prevent gender-based discrimination and uphold women's rights as well as the rights of the fetus. Further, we would like to mention that the fetus does have a right to life. And my lords, if you turn to page 16 of the compendium, there is a very recent judgment given in the case of State of Rajasthan versus S, wherein the court has held in para 30 that the right to life of the prospectus child needs to be given precedence over the rights of the petitioner. The fetus is given the protection of Article 21. Further, moving on to issue 2, which states that the legal framework sufficiently safeguards the rights and welfare of children born out of live-in relationships. In this regard, the counsel for the respondent contends that the current legal framework, first of all, recognizes the legitimacy of children born out of live-in relationships. My lords, there are multiple judgments wherein the legitimacy of children born out of live-in relationships has been recognized. The court has stated that regardless of the marital status of the parents, the child is innocent and the child must be protected by all the laws, the same way any child who's born out of a wedlock would be protected. Secondly, there is a judgment, a landmark judgment of Tulsa versus Durgatia, which is page 8 of the compendium. This judgment states that prolonged cohabitation raises a presumption of marriage under section 114 of the Indian Evidence Act, which also helps to ensure the legitimacy for children born out of live-in relationships. Secondly, the criminal procedural code under section 125 provides for maintenance as well for these children. The counsel for the petitioner also specified that section 16 clause 3 of the Hindu Marriage Act does not recognize live-in relationships. But my lords, there are several judgments, one of them being Indubai Jayadeo Pawar versus Draupada 2017 judgment by the Bombay High Court, which recognizes that section 16 covers children born out of live-in relationships as well. In the instant case, if the petitioner has to undergo with the pregnancy and if the child is to be born, this child will be fully protected under all existing laws, just like any other child will be. Secondly, Under the same contention, under the same issue, the respondent contends that Article 14 guarantees equality to all the children. This child, if it is allowed to be born, would be protected under all welfare schemes as well, such as the Right to Education Act. Right to education is one of the most important rights given in our constitution. Secondly, the child will also get the benefits of integrated child development services, which is one of the missions of which is to provide care and protection for children, especially those in difficult circumstances. Therefore, my lords, based on the arguments which have been presented before you for the first two issues, and based especially on the fact that all the authorities, most of the authorities which have been relied upon by the counsel for the petitioners are completely baseless, we fail to understand what the petitioner is actually trying to seek from the court. My lords, they have relied on very unfounded and wrong judgments. The counsel for the petitioner is disrespecting the court and attempting to mislead the court by citing wrong judgments. And in fact, they should be held in contempt of court for trying to make a mockery of justice itself. With this, my lord, I would like to pass the mic to my co-counsel for the rest of the issues.
My one question, I'm actually confused about this entire arguments and counter arguments. Simple question, whether MTP Act permits or prohibits pregnancy per se.
Permits or prohibits pregnancy?
Termination of pregnancy per se. Or is it permitted within 12 weeks also on certain grounds?
My lord,
Does India recognize termination of pregnancy per se?
yes, my lords, the country.
Where?
Up to 20 weeks, termination is allowed without any restrictions. Post 20 weeks.
Are there any other conditions which have to be satisfied for termination of pregnancy? Or is it anybody, is it free for all? Any woman who doesn't want pregnancy can walk into any clinic and seek termination if she is within 12 weeks or 20 weeks.
My lords, within 20 weeks.
It's a matter of right?
Yes, my lord, it is a matter of right within 20 weeks.
Which section says that?
Just a second.
You can read and come back. After your co-counsel has argued, you
Yes,
just read this and tell me which section says that India recognizes per se right of termination of pregnancy. If it is within 12 weeks or 20 weeks.
My
right?
lords,
Just read and then come back, right?
Sure, my lords. Can I cite one article before that? I want to cite Article 21. It has been recognized by the court that there is the right to reproductive autonomy, which falls under Article 21.
Does India recognize right of termination of pregnancy per se?
Yes, my lord, it does.
It does?
It does.
In the judgments or in the act?
In the judgments, there have been
Not in the
several
statute.
If I could get
That's
back
what
to you
I'm
about the
saying.
statutes.
The council is well aware of the presence of my ladyship on the bench, but for the sake of convenience, the council seeks permission to address the bench collectively as my lords. Much obliged, my lords. My lords, before I begin, the council has observed that my lords are burdened with the paperwork here. So if my lords could just keep the compendium submitted by us, the moot proposition and the memo submitted by the petitioners handy, because my lords, all the arguments that I will be making, it will be relying primarily on these only, my lords. Now, my lords, at the outset, I would state that the facts submitted and stated by the counsel for the petitioners are not just incomplete, but also incorrect. So, my lords, during the proceedings and during my pleadings, my lords, I will state the correct facts and also rely on the moot proposition wherever the facts are required, my lords. And my lords, along with the facts, as has already been highlighted by my co-counsel, that the counsel for the petitioners have highlighted, have relied on factually incorrect case laws. My lords, the same will be highlighted by the counsel before this honorable court. Now, my lords, my co-counsel has already dealt with the first two issues before this honorable court, and I will be taking over for the remaining three issues. My lords, the third issue states that whether the state's deployment of AI-based surveillance systems such as Matri Suraksha AI and Jivika AI are violative of constitutional privacy rights and other legal rights. Now, my lords, the question itself states about two AI systems, Matri Suraksha AI and Jivika AI. But my lords, nowhere in their pleadings or nowhere in their memo have they ever mentioned about Matri Suraksha AI, my lords, as to how that is violating their rights, the rights of their petitioners. In fact, my lords, if my lords were to refer to para 3 of the moot proposition itself, it mentions that Matri Suraksha AI aids in diagnosis. So, my lords, the very diagnosis which the petitioners are relying on, Matri Suraksha AI has been aiding in it. So, my lords, if they are to say that Matri Suraksha AI is violative, it's violative of their constitutional privacy rights, and my lords, why are they using this diagnosis as well? Because Matri Suraksha AI has aided them in this diagnosis. No, but my lords, taking forward the argument, we believe, and it is being argued by the counsel for the respondents, that even Jivika AI does not violate any constitutional privacy rights or legal rights. Now, for the very same reason, my lords, the first contention put forward by the counsel for the petitioners was regards to the violation of Article 21. And my lords, for the very same reason, they mentioned about the proportionality test as laid down in the case, Puttaswamy case. And it is also mentioned, and they have also referred to the same on page 12, para 33 of their memo, my lords. But my lords, just stating about the proportionality test and then making a statement that Jivika AI violates the same, my lords, how can that be held as valid in a court of law? So, my lords, for that very reason, the council would take forward this very argument and state that how this very Jivika AI and the deployment of this AI, it is proportional and it is not violative of any rights. Now, for that very reason, my lords, the four requirements under the proportionality test are that the measure must be sanctioned by law, which I will be delving upon later, my lords. The second being that the objective must be legitimate. Third, that the measure must be necessary. And fourth, that the measure must have procedural safeguards. Now, my lords, coming to the very first aspect of measure be sanctioned by law. Now, for that very reason, if my lords were to refer to the compendium at page 33, now, my lords, since we have also mentioned about the compendium, I would also highlight this very important aspect that, my lords, none of the documents submitted to my lords was ever served upon the counsel for the respondents. Now, coming to page 33, my lords. Are my lords with me? Yes. So, my lords, I am quoting section 7, clause G of the Digital Personal Data Protection Act. A data fiduciary may process personal data of a data principal for any of the following uses, namely, and under clause G, my lords, for taking measures to provide medical treatment or health services to any individual during an epidemic, outbreak of disease, or any other threat to public health. My lords, we believe, and it is being argued by the counsel for the respondents, that this very step, it gives that Jivika AI is serving the legitimate state function of preventing female feticide, a grave concern which is also regulated under the PCPNDT Act, my lords. Now, my lords, going forward, with regards to the factually incorrect and incomplete statement made by the counsel for the petitioners, if my lords were to refer to Annexure 4 of the moot proposition. Are my lords with me? Yes. So, my lords, under this, my lords, if my lords may refer to the subheading of follow-up notes, my lords, it states a sentence that investigative findings revealed that the alert was a false positive. So, my lords, none of the reports are being solely based and solely relied on Jivika AI. All the reports submitted by the Jivika AI, it's going through a human, it's going through a manual verification, my lords. So, my lords, on what basis are they stating that Jivika AI is arbitrarily imposing and violating the constitutional rights of the petitioners? When, my lords, even in the present case, it went through the manual verification and it was rather indeed a false positive. So, my lords, how has Jivika AI violated any of their rights, my lords? Now, going forward, my lords, if my lords would also refer to IT rules of 2011, which is at page 34 of the compendium. My lords, rule 5, clause 2, with regards to collection of data. My lords, body, corporate, or any person on its behalf shall not collect sensitive data, personal data, or information unless the information is collected for a lawful purpose, connected with a function or activity of the body, corporate, or any person on its behalf, and the collection of the sensitive personal data or information is considered necessary for that purpose. My lords, for in this present case, the data collected of the petitioner, that is Sneha, it's being used only for a selective purpose, that whether the abortion decision taken by the petitioners is with regards to sex selective abortions or not, my lords. My lords, this data is not being processed for any other purpose. Now, going forward, my lords, if my lords were to refer to the memo submitted by the petitioners at page 12, para 29, my lords, they have made contentions that that my clients have financial incentives in this deployment of Jivika AI. But my lords, we fail to understand that when it is state deployed, how would a state have financial incentives with regards to the same? My lords, this is only used to regulate and to curb sex selective abortions, my lords. Now, if my lords are satisfied with issue 3, please may I, if I may just proceed to issue 4, my lords. Certainly, my lords, much obliged. Now, my lords, issue 4 before this honorable court is whether judicial oversight in abortions unjustifiably infringes on a woman's right to timely medical care and reproductive autonomy. Now, my lords, if my lords were to pay attention, were to just note page 14, para 39 of the memo submitted by the petitioners. My lords, it's a very important note to be made here. My lords, they have made allegations that because of this Honorable High Court's prolonged process, the petitioners have suffered. But my lords, we fail to understand that where have they come to this conclusion? It has neither been mentioned anywhere. It's not been mentioned anywhere in the fact sheet as well, my lords. My lords, in fact, if my lords were to refer to the moot proposition itself, it states that the moment Sneha and Rohan Dadi, the petitioners, approached this Honorable High Court, it was at that very moment that this High Court constituted a medical board to look into the matter. So, my lords, how have they made this allegation that coming to the High Court, it's a prolonged process due to which the petitioners are to suffer? Now, going forward, my lords, the respondents emphasize that the issue before this court is not about restricting reproductive autonomy, but about maintaining a necessary balance between competing rights. My lords, the action taken is designed to prevent arbitrary terminations and ensure that the interests of both the mother and the fetus are adequately considered. My lords, when statutory limitations conflict with evolving medical advancements, judicial intervention ensures an informed and constitutionally consistent interpretation, my lords. Now, also, my lords, if my lords were to refer to page 16, para 46 of the memo submitted by the petitioners, the counsel for the petitioners, my lords, they have relied on independent thought versus Union of India. My lords, we fail to understand that how is that case relevant to the present scenario? My lords, that case was with regards to the rape of a minor wife. My lords, how is it even relevant to the present scenario? And now, my lords, if my lords would also refer to page on the very same page to the very next para, that is para 47, my lords, they are themselves suggesting that since it's a medical issue, a medical board should look into it and similar arguments. But my lords, then who is going to constitute this medical board? For that very purpose, we also need this Honorable High Court so that it can constitute the medical board, my lords. Now, my lords, along with that, if my lords may have also paid attention to the arguments put forward by the counsel for the petitioners, it was that, my lords, since the baby is going to face, my lords, they mentioned a lot of problems, and my lords, my apologies if I don't pronounce the issues properly, but it was anencephaly, if I'm not mistaken, my lords. And my lords, because of this, my lords, they also stated that the baby may be non-viable. But my lords, if this very argument is to be taken forward, then my lords, they are also providing justifications to to the legalization of active and passive euthanasia. That, my lords, if somebody is not able to live properly, maybe they be given the right to, maybe they be given the right to just die. And my lords, just coming to the last leg under this issue.
One question. If you've read section 3,
Yes, my lords.
it permits the termination on 2 conditions.
Yes, my lords.
What are those 2 conditions?
My lords, it beyond 20 weeks. Yes, is that my lords?
What, and before 20 weeks?
My lords, I would apologize for my
All right.
ignorance with regards
What
to
are
the
those
same.
2 conditions under which termination is allowed? There are 2 conditions which are required to be satisfied.
My lords, if I may just refer to the section as well, and
Yeah.
And just take a minute to go through the same and
We'll
answer.
read it together.
Fair enough. my
We'll
lords.
read it together.
So, my lords, should I read it?
Yes,
this?
please.
Okay, my lords. So, my lords, section 3 of MTP Act 1971, which is mentioned in our compendium at page 27. Section 3, when pregnancies may be terminated by a registered medical practitioners.
Clause 2. Come straight to clause 2. Next page, second line.
After explanation.
Subject to the provisions of subsection 4. Top.
Yes, my
Yes.
lords. Subject to the provisions of subsection 4, a pregnancy may be terminated by a registered medical practitioner where the length of the pregnancy does not exceed 20 weeks if such medical practitioner is, or where the length of the pregnancy exceeds 20 weeks but does not exceed 24 weeks in case of such category of women as may be prescribed by rules made under this act, if not less than 2 registered medical practitioners are of the opinion formed in good faith that, clause 1, the continuance of the pregnancy would involve a risk to the life of the pregnant woman or a grave injury to her physical or mental health, or clause 2, there is a substantial risk that if the child were born, it would suffer from any serious physical or mental abnormality.
Right. So the discretion is given to the practitioner that if he finds that there'll be a medical abnormality in the child, he should take an informed decision to terminate. Here, the medical record is showing that the child would not be viable. It may not even survive few hours after the birth or may even die before. Is it not a fit case where the medical practitioner himself should have taken the call to terminate?
My lords, very respectfully with regards to the same, if my lords would also refer to Annexure 3 of the moot proposition, wherein the majority of the medical board it held that despite the fetal anomalies and minimal survival prospects, advancements in neonatal care could potentially sustain the fetus temporarily post-birth.
Temporarily. See, here again, my question is, the opinion of the medical board is only an expert opinion?
Uh,
It's only an opinion?
my lords, we believe that since this was constituted by the
So
Honorable
it
High Court
becomes
itself,
gospel when they are themselves notifying certain facts. They themselves are saying the child would not survive, right? He may be born, but for how long? And they themselves are saying that the child is abnormal. So should the medical practitioner be not justified to take an independent call on the basis of the findings, not on the opinion, but on the findings that it is a fit case? Does it not qualify under section 3? Does it or does it not qualify?
my lords, we believe that for the very same reason, it should be the medical practitioners who look into the very same aspect. And with regards to the same, my lords, if I may just point out another very important aspect here, my lords, if my lords were to refer to Annexure 1, those are the diagnostic test results which were laid out by the Metro Layer Hospital, which we are representing. And my lords, Annexure 2, if my lords were to refer to Annexure 2, it was the medical board which was constituted by the same hospital. So, my lords, there is somewhere that the medical practitioners at this hospital, they believe that there are chances for the survival of the fetus. And my lords, there's something which, my lords, we believe that it is something which should be left to the medical practitioners because it's involving a serious medical issue, my lords.
So should the termination be done or not?
My lords, we believe for that very purpose, if my lords, the counsel for the respondents is ready, if my lords were to constitute another medical board spontaneously, and maybe tomorrow itself the medical board takes the
Would
decision.
it not be counterproductive to your own argument that the time is the essence, but once you go to the court, it gets prolonged unnecessarily when everybody has given one opinion that the child would not be viable? Secondly, when you are referring to this annexure to the medical board, and there was also an argument that it was not constituted properly, if you read section 3, what it says is that you may have an opinion of two medical practitioners. It is not talking of medical board. Medical boards are generally being appointed by the courts. So
Yes,
your reference to this annexure 2 as an opinion of a medical board is incorrect.
my
It may
lords,
be written whichever way, but this is only an opinion of two doctors as is mandated under section 3. What is a medical board is annexure 3, which got appointed by the directions of the court. Right, so
yes.
you need to correct the fact. My moot question again remains that whatever be the opinion, what are the facts by the doctors at all levels that the child is not normal?
My lords,
Then should the doctor not take a call that considering all this, it is the termination should be done?
my lords, very humbly with regards to the same, my lords, during even during the medical board, my lords, they are the two medical practitioners, and my
They are
lords,
not board. This is the opinion of two doctors as is mandated under section 3.
yes, my lords. My lords, for that very purpose, if my lords were to also refer to maybe Annexure 3, wherein another medical board was constituted and only one medical practitioner stated that they can go ahead with the termination. Rest three medical practitioners, my lords.
Are you
they
going to be
stated-
bound by the opinions? What is the status of opinion evidence under law?
my lords, under the opinion, we believe it's the expert opinions, my lords, which have been given forward by the medical board, which is also covered under section 39 of the BSA, my lords. And my lords, we believe that since if my lords were to refer collectively and through the large scale, my lords, it's primarily as if 5 medical practitioners have stated that the fetus can live. There are slight chances, very slight chances, but it can live. And only one medical practitioner has stated, my lords, that the abortion should be the way forward. So with regards to the same, my lords, if that argument is to be taken forward, then we believe, my lords, that pregnancy should not. My lords, with regards to the same as well, since my lords have already pointed with regards to termination of the pregnancy by the petitioners, my lords, they have nowhere prayed. They have nowhere given this prayer that they are seeking the termination of the pregnancy. It is only being highlighted in their pleadings, my lords. They have not given any prayer with regards to the same. If my lords are satisfied with issue 4, if I may just proceed to issue 5, my lords. Much obliged, my lords. My lords, the fifth issue before this honorable court is whether the findings and conclusions of AI-based systems such as Jivika AI are reliable and legally admissible as evidence in medical and judicial proceedings. Now, my lords, we respectfully submit that Jivika AI is a crucial technological advancement that fills the systematic gaps in Indiana's healthcare infrastructure. It operates with a robust regulatory framework and meets the evidentiary standards for admissibility under the Indiana law. Now, my lords, I'll just break it down into a few parts, the arguments with regards to the same. My lords, Jivika AI is essential for healthcare efficiency and gender justice. Indiana's healthcare system suffers from chronic shortage of medical professionals, inadequate access to quality care, and administrative inefficiencies. My lords, being the state, we are well aware of the same, and we are taking positive steps to remedy the same. My lords, deployment of Jivika AI is also one such step. AI-based diagnostic tools such as Jivika AI, they function as assistive mechanisms rather than independent decision makers, my lords. My lords, which I've already highlighted earlier as well with regards to Annex 4, that even in the present case, the Sneha, that is the petitioner's reports, were flagged by Jivika AI, which then went through a manual verification, wherein it was stated that it's a false positive and it's not a case of sex selective abortion, my lords. Now, my lords, we also believe that ICMR guidelines play an important role when the state deploys any such kind of an AI mechanism or any tool in healthcare systems. My lords, the same has not been highlighted by the counsel for the petitioners, but my lords, we believe that that job would be taken over by the counsel for the respondents. And my lords, now just highlighting 3 guidelines under the ICMR guidelines. My lords, I said this argument will be taken care by the counsel for the respondents. And my lords, I'm respondents. And my lords, they're... Yes, my lords, that's what... And my lords, just apologies, my lords. My lords, just a small clarification that it's not appellants, but it's petitioners. It's the mistake that they made, my lords, but yeah. Now, my lords, with regards to the ICMR guidelines, we are referring to 3 of the guidelines as of now, my lords. But if my lords require assistance with any of the other guidelines as well, we'll submit in the next hearings, my lords. Now, my lords, coming to the very first guideline with regards to accountability and supervision. My lords, the state government, it's directly supervising the deployment of this Jivika AI. So, my lords, we are meeting this ICMR guideline. Now, coming to the second part, my lords, that human autonomy is maintained, which my lords have already highlighted that it's going through manual verification. And yes, my lords, the third one being about privacy and data protection measures in place. And my lords, we believe that Jivika AI has not violated any of the same, and it's being used only for a selective purpose of curbing sex selective abortions, my lords. Now, my lords, on page 20 of their memo, they have made allegations of incomplete scientific validations. Now, my lords, we fail to believe that what are they referring to as incomplete scientific validations in this line here, my lords. And my lords, another very important aspect, if my lords were to refer to page 20 at para 59, my lords, the counsel for the petitioners have relied on cases such as Selvi, but my lords, we don't understand how is it relevant to the current scenario. My lords, the case of Selvi versus state of Maharashtra, it's on the right against self-incrimination, my lords. My lords, how is it even relevant in the present scenario? Now, also going forwards, my lords, if I may just conclude with this final part, my lords, with regards to as to how Jivika AI is admissible under the BSA. Now, my lords, under section 63(2) of the BSA, it permits the use of computer-generated data as electronic evidence. My lords, Jivika AI is regularly used and lawfully controlled in hospitals fulfilling the statutory requirements. My lords, under this very section, there is a requirement for production of certification. Whenever the certification is required, my lords, it can be produced by the Metrolia Hospital. And my lords, but along with that, there's also this case of Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorantyal, which we have mentioned in our compendium at page 20. Manoj, this very important case law stated that even if you're unable to provide certification, if you're ready to provide and show the very AI sample or the electronic evidence in the court itself, it can be admissible. And my lords, we are ready to bring Jivika AI in this honorable court whenever the court demands. Now, with regard, and my lords, with that, if I may just proceed to my prayers. My lords, my lords, it has already, before I just state my prayers, my lords, if my lords were to refer to their prayer itself, my lords, I've already highlighted that they have not asked for the termination of pregnancy. My lords, also with regards to prayer 3, it states to hold that, and my lords, if I may just quote what it says, it states to hold that the state's deployment of AI-based surveillance systems such as Maitri Suraksha AI and Jivika AI violates constitutional privacy rights and other legal rights of a person. My lords, if I may just take 2 minutes and my lords, we fail to believe that what are they seeking here? Is it a stay order they are seeking, or what exactly are the counsel for the petitioner seeking here? And now with that, if my lords, if I may just proceed to our prayers, and my lords, with the permission of the honorable court, if I may just quote it verbatim. Wherefore, in consideration of the questions presented, arguments advanced, and the authorities cited, the counsel for the respondents most humbly and respectfully pray that the Honorable High Court of Andhra Pradesh be pleased to adjudge and declare that 1. Hold that the 20-week restriction under the MTP Act is constitutionally valid as it serves a legitimate state interest in protecting maternal health, preventing misuse of abortion laws, and balancing reproductive rights with the state's duty to protect life. 2. Declare that the legal framework in Andhra Pradesh sufficiently safeguards the rights and welfare of children born out of live-in relationships, ensuring they are not discriminated against and are entitled to legal protections under existing laws and judicial precedents. 3. Uphold the constitutional validity of the AI-based surveillance systems, including Matri Suraksha AI and Jivika AI, on the ground that they do not violate any of the constitutional and legal rights. 4. Hold that the judicial oversight in abortion decisions does not unreasonably infringe upon a woman's reproductive autonomy, as it ensures decisions are based on legal and medical assessments while maintaining a balance between personal liberty and state's obligation to protect maternal and fetal health. My lords, we would request to omit prayer 5. We've put in the paperwork as well with regards to the amendment of the prayers, my lords, and the same be directed to be omitted. 6th, my lords, direct that the petitioner's challenge to the constitutionality of the 20th week be dismissed, as the restriction is based on medical risks, fetal viability, and ethical considerations, and does not violate the fundamental rights of pregnant individuals. 7th, hold that the AI-based surveillance mechanisms do not infringe upon the right to privacy, as they meet the proportionality test as laid down in K.S. Puttaswamy. 8th, declare that the judicial oversight in abortion cases is necessary to prevent the arbitrary exercise of discretion and to ensure that medical terminations beyond statutory limits are granted only in exceptional circumstances in accordance with constitutional principles. Lastly, hold that Jivika AI and similar AI-based systems improve healthcare efficiencies, address infrastructure gaps, and assist in healthcare decision-making, thereby promoting equitable access to medical resources and fulfilling the state's duty under Article 47 to improve public health. And my lords, along with that, if this honorable court may pass any other order that this honorable court may be pleased to grant in the interest of justice, equity, and good conscience. And my lords, with that, barring the right to subuttles, we rest our case.
One question to you is, which has been highlighted by them, that none of the relief pertains to this woman, the lady. All your prayers are more in the nature of PIL. So what have you filed? A writ petition specific to the woman or a PIL seeking generalized directions, AI not good, High Court's intervention not good, limitation of 20 weeks not good. So what have you done in this writ of yours? Is it PIL or is it specific to the petitioner?
Your Lordship, we have filed a writ petition under 226, particularly the writ of mandamus. Your Lordship, to command. Your Lordship, it is an individual right enforcement, Your Lordship. Just 1 second, Your Lordship. Your Lordship, all of our prayers do indeed include the rights of our client as well, because Your Lordship, is the general rights. Your Lordship, if the general rights are amended, then it would also include our client in it as well, Your Lordship. If I, much obliged, Your Lordship. Your Lordship, the opposing counsel seems to be lacking in content, as much of what happens in rebuttals have already been stated by them in their arguments, Your Lordship. And further, the opposing counsel also seems to be misdirecting the court, as they are contending that precedents set by the court don't matter, and merely the facts by contending various of the cases we have cited. Your Lordship, by this contention, many of the cases which they themselves have stated are also inadmissible, Your Lordship. Further, Your Lordship, the opposing counsel has also stated that in cases cited by us, where we said that 24 and 25 week exception was also granted, Your Lordship, they have stated that there was no mental trauma. By presenting this argument, they are contending that sexual assault does not indeed include or result in any mental trauma, Your Lordship. Further, Your Lordship, on page 21 on my learned opposing counsel's memo, in the third paragraph, Your Lordship, they again attempt to misdirect the court, as they state that Jivika AI merely flags cases for review under PCP and DTI. Your Lordship, meanwhile, in the page 3, para 12 of the prop itself, it states that investigative reports reveal that Jivika AI suffers from algorithmic biases. The system disproportionately targets unmarried women. Your Lordship, it doesn't merely just record data, it disproportionately targets unmarried women and live-in couples and those from marginalized socioeconomic groups. That is all, Your Lordship. That is all we can do. Much obliged.
My lords, my lords, at max 1 minute or 1 minute 30 seconds at max, my lords. My lords, our dear respected counsels here have made grave allegations that the cases cited by us are wrong and similar kind of arguments, my lords. But my lords, they have not provided one single case where there has been a wrong citation or a case with wrong facts have been cited in this current scenario, or any wrong case which has been argued before this honorable court. Now, my lords, since our respected counsel here, he himself stated while referring to our memo that Jivika AI flags for human review under PCP and DT, referring to page 21 of our memo, my lords. My lords, that's what precisely even I stated. And it's how is it false, my lords? Because if I've already shown to my lords that while referring to Annexure 4, it is going through a manual verification. So, my lords, how is this factually incorrect? Now, my lords, I believe that, my lords, with regards to this, we have cleared and contradicted any allegations put forward by the counsel for the petitioners. And, my lords, with that, the counsel for the respondents rests its case. The extra time that the speaker has. There's a one more point. The chips to the speaker has not been passed by the researcher.
All I would like to end it with saying that all of you are brilliant. You, with at times, you struggle with the facts and there being lack of clarity. Despite that, all of you have done fantastic. I've tried to, do full justice to for the young minds. I think it was tremendous presentation of case by both the parties, and I can only say that you all are surely gonna be great advocates. If you choose to be, unless you decide to take any other vocation. And I'll just end by saying this again, we have not, this is not the evaluation, but generally, I noticed that this compendium has been handed over by the respondents, and the petitioners maybe were right in handing over individual documents, but generally, it is better if you compile it and give it in one go. Secondly, never do it like this, the way it has been done. Firstly, there should always be an index, right? Secondly, what I noticed was that you have taken out relevant parts and just put that. Even when you're doing that, there should be some indication. Your Data Protection Act and your the other act, I think IT Act, they are all on the same page. It looks as if it is part of one document. So whenever you do it, just segregate it. Relevant part of a judgment, you should say the first page, and then you indicate that we are going only for the relevant part. So that will just help you to put your point more clearly. At times, you may be saying something like indexing, like page number. I was not able to see that the page number was at the end. It generally you look at the top. So those kind of small things. And what is better is, I won't say anything because according to you both, you have given the written arguments here, but generally have more concise written arguments with corresponding page number and judgment indicated, so that it's easier for this law point, this judgment page number. So, right? That's only general comments. And all I can say is all of you are winners, right? Good luck.
Sahib, bateं udah practice